Good evening. Corey? Or
Hi,
Mark?
thank you. Hi, my name is Corey. I'm here from Monroeville Public Library. Thank you all for joining us this evening. We want to thank the folks from Pennsylvanians for Modern Courts for helping put this together, as well as Attorney Frank Walker and Judge Elliot Howsie.
Good evening. My name is Tom Bailey. I am the PMC Pittsburgh Program Coordinator. Thank you for attending this evening. Pennsylvanians for Modern Courts is the only statewide nonprofit, nonpartisan organization dedicated to ensuring that all Pennsylvanians can come to our courts with confidence that they will be heard by qualified, fair, and impartial judges. The tools we use to achieve these goals are listed at the bottom of each slide for this evening. We emphasize civic engagement in education, equal access to justice, and judicial modernization and reform. Examples of these are in Pittsburgh. We have initiated a Pittsburgh Bail Watch. We have volunteers that observe preliminary arraignments at the Pittsburgh Municipal Court building, and they record what they see and write down their comments. That's civic engagement. In regards to civic education, we conduct workshops like this one to educate residents about our court system. And we also advocate for judicial modernization and reform. We advocate for the reform of judicial selection and discipline processes. We present candidate forums during judicial election years. And we also provide ethics courses for judges and lawyers as professional development. So as we begin this evening, should you have technical issues, please email us at staff@pmconline.org. Tonight's presenters are discussing general legal topics. They are not giving legal advice. Should you wish specific legal advice, please consult an attorney of your choice. This program is being recorded, and the recording will be available at our website, www.pmconline.org, and then click on resources, and you'll see all of our past, prior workshops that have been recorded. We want to hear your questions, and we ask that you put your questions for our presenters in the chat. Our speakers for this evening, Frank Walker. Frank Walker has served as a senior trial attorney for the Allegheny Office of Conflict Counsel in Pittsburgh. He then joined the litigation department of Strasburger, McKenna, Gutnick, and Geske. Since 2011, he has operated a solo practice of Frank Walker Law with 2 offices in Pittsburgh and Morgantown, West Virginia, and he specializes in criminal defense and personal injury cases. He also teaches criminal law at West Virginia University College of Law, the Advanced Criminal Procedure class. Judge Elliot Howsie. Judge Howsie clerked for the Honorable Justin M. Johnson on the Pennsylvania Superior Court. He has worked as Allegheny County Assistant District Attorney for 5 years. He also has operated a solo practice dealing with criminal defense and personal injury. In 2012, he was appointed as the Chief Public Defender of Allegheny County. In 2019, he was appointed to the Allegheny County Common Pleas Court, where the fall of 2021, he was elected to the Allegheny County Common Pleas Court for his first 10-year term. Our agenda tonight has 3 sections to it. The first is the presenters will discuss investigation and arrest, and then there'll be a question and answer period. Then they will look at the magisterial district court process, preliminary arraignments and preliminary hearings, and a second question and answer period. And then they'll look at the Allegheny County Common Pleas Court process and a third and final question and answer period. Gentlemen?
You know what, let me say one thing before you start. We are not here giving any legal advice. So we want everybody to understand that we're providing general information, and there are certain and questions that a judge may not be able to answer because of the Code of Judicial Conduct. So I also want you to be aware of that. But other than that, thank you. I'll hand it off to whoever's starting. Thank you very much.
All right. Thank you. Thank you, Pennsylvania Courts for Modern Justice. And thank you to the Monroeville Library for having me. And thank you to Judge Howsie for joining me on this panel. So let's start with the Pennsylvania State Court System. It starts at the top, Supreme Court. That is the highest court in the Commonwealth. The court directly below them is Superior Court and Commonwealth Court. They sit on the same playing field. The most court that people mostly know about is the Court of Common Pleas, otherwise known as Big Court. And then they have Pennsylvania District Courts, PMC Court, and Philadelphia Municipal Court. Now I'll go in reverse order to make it a little bit more familiar to you. If you first get arrested, you're going to start off in the municipal court at the bottom. And if your case is held for court, then it's going to move to Common Pleas Court. Then you have the right for appeal to Superior Court, and there is a discretionary right of appeal to Supreme Court, but that is discretionary only. And we'll get into that a little bit later. Judge, feel free to jump in at any time. We're going to make this a lively discussion. And again, to everyone who's watching, thank you for coming. But please reserve your questions and comments to the appropriate slide where we answer those questions. So Judge, any questions before we move forward on this one?
Thank you as well. Good evening to everyone. So again, with the municipal court, a criminal matter may begin in a municipal court by magisterial district court by way of a preliminary hearing, but that is also a place where small claims cases are initiated or landlord-tenant complaints. Those cases will also be resolved in Court of Common Pleas, which is our trial court. And as a matter of right, those cases can be appealed to Superior Court, as Mr. Walker stated. Our Commonwealth Court is the equivalent of our appellate court for administrative matters. So if you had a legal challenge with the Pennsylvania Utilities Commission over your utilities, that court is the court that would hear any appeals regarding any issues regarding administrative matters. All cases have ultimately will be resolved in the Supreme Court, but that is discretionary with the court.
Criminal prosecutions are initiated, as the judge stated, by traditional arrest. You can see a person handcuffed and taken to jail. I think you understand you're under arrest when you're in handcuffs. That's common sense. Another way they can initiate arrest is by summons. Let's say you are stopped for a DUI or a non-violent offense. Typically, they will mail you a summons, which is a big, thick envelope you'll get in the mail. So if you did something crazy or you forgot what you did over the weekend, and all of a sudden you get a notice that there's something coming at the post office, odds are that is your summons telling you to bring yourself and your attorney down to the local municipal court so you can address those charges. In order to have any arrest, it has to start with probable cause. So we'll get more into that a little bit later on. Judge, anything else?
I would just say, typically, cases will be resolved with a traditional arrest in most instances in the city of Pittsburgh. Your smaller municipalities typically will initiate a criminal prosecution by way of summons. And that process takes approximately, I'd say 6 weeks from the date of your contact with that officer. You should expect to receive a summons in the mail. So any nonviolent offense or low-level misdemeanor will almost always be charged by way of a summons, which is nothing more than a court order directing you to appear at your initial proceeding, which will be a preliminary hearing at district court. But again, in the city of Pittsburgh, they rely more heavily on arrest as a way of initiating the criminal court process.
Now, before we move forward on this one, another way you can notice, make sure I'm okay, you can hear me. Another way you'll notice that a charge or a case has been started against you is even if you haven't received the summons, you may start to receive letters, which are advertisements for different attorneys, advertising stating that you've been arrested. When you start to receive that, odds are the summons is on the way. So just be prepared. They will mail it by certified mail, and they'll also mail a regular copy to your address. So whatever address you gave or that was available to the officer when they stopped and arrested you, that is the address the mail will go to. So next slide. The grading of criminal charges in Pennsylvania. Pennsylvania has 4 classifications of criminal offenses. There is homicide, there's felony, misdemeanor, and summary offenses. Summary offenses, the maximum penalties are all spelled out on the slide here, but summary offense is, as an example, is maybe underage drinking. I like to call them stupid crimes. Underage drinking, public urination, public intoxication, disorderly conduct, you're fighting with your neighbor, loitering, littering, public consumption, Things like that. Those are the crimes that are classified as summary offenses. Misdemeanors are kind of like a step up, like a DUI, a theft, a retail theft for first offense. There's assault that can be classified as a misdemeanor. There's criminal mischief can be classified as a misdemeanor. There are a couple other crimes to be classified as a misdemeanor. Felonies, when it starts to get, now you're in the big leagues. That's the big F on your record, and that's what you don't want. You don't want anything, but definitely want to avoid the felony. Those are the robberies, the sex offenses, the firearms charges, aggravated assault, vehicle theft if it's over a certain amount. So those are the felony charges, and odds are you're looking at some serious jail time and maybe even prison time for those charges. And homicide is pretty much the death of another human being, loss of life. Penalties can include life in prison or even up to the death penalty, depending on where we are with that litigation in Pennsylvania. So those 4 classifications: homicide, felony, misdemeanor, and summary offenses. And every person charged with a crime is accused, and they are innocent until proven guilty, which we'll talk a little bit more later on. Judge?
Thank you. I would just add in with summary offenses, traffic violations are summary offenses as well. If you were to run a stoplight or run a stop sign, or if you were speeding, those are summary offenses as well. Misdemeanors have 3 grades of misdemeanors. There's a first-degree misdemeanor, which is our most serious misdemeanor, punishable by a maximum of 5 years in prison. Second-degree misdemeanor, punishable by a maximum of 2 years in prison. Third-degree misdemeanor, punishable by a maximum of 1 year in prison. You also have third-degree felony, which is punishable by a maximum of 7 years in prison. Second-degree felony, punishable by a maximum of 10 years, and first-degree felony, punishable by a maximum of 20 years in prison.
Now, before we move on, I'm sorry, Judge, were you done with that slide?
I was just going to say, when we talk about homicides, there are different classifications of homicide. The worst homicide you can commit is a specific intent homicide, first-degree murder. It's intentional, willful, deliberate taking of another person's life. There's also voluntary manslaughter, which is an intentional killing as well, but not as serious as first-degree murder. There's second-degree murder, which is a murder committed during the commission of a felony. And then there's third-degree murder, which is a reckless disregard or depraved heart killing. You engage in extremely reckless conduct, which results in the loss of life. And then there's also involuntary manslaughter, which is probably our least serious classification of homicide. That would be the situation where someone accidentally shoots another person during hunting, or a motor vehicle accident, someone loses their life.
Thank you, Judge. Also, for summary offenses, you'll see a subsection of summary offenses called non-traffic offenses. There are summary offenses, but they come in a different format. A lot of times there are citations and they're held in a different courtroom, and you'll get a notification for a summary trial. So that is a little bit different from the summary offenses. Usually the summary offenses are coupled with a misdemeanor offense. But if you give a non-traffic offense, you're probably going to go to a different courtroom within the same courthouse. So just pay attention to everything you get in the mail, and pay attention to the lettering and the docket numbers. If it's an NT as in Nancy Tom or non-traffic, then it's a non-traffic offense. If it's a summary offense, it will say summary offense on there also.
If I may, a misdemeanor, an example of misdemeanors would be an assault. If 2 people were involved in a fight and the injuries were not serious, that would be a misdemeanor. A theft of goods of say under $250, that would be a misdemeanor. Resisting arrest, recklessly endangering another person. Those are all examples of misdemeanors. Typically your assaults, your low-level thefts in terms of the value of the theft, those would all be examples of misdemeanors.
All right, now we have the criminal procedure for misdemeanor and felony offenses. We gave you a little bit about it, starting with the arrest, the investigation, and the arrest. And then you go to the preliminary arraignment. That is where you, also known as your bail hearing, where charges are read. There's no facts about the case. It's just you're going to enter a plea of not guilty. The charges are read to. You're going to get a copy of your paperwork for your case. That is usually called your criminal complaint, your affidavit of probable cause for the charges against you. You do not have the right to counsel at this hearing, and the determination will be made about bail at the preliminary arraignment. The preliminary hearing, 2 things need to be proven. 1, that a crime was committed. 2, you're more likely the person who committed the crime. Credibility, who's lying, none of that is an issue at a preliminary hearing. In other words, is there enough evidence to move forward to go to big court, what we call the Court of Common Pleas? So after your preliminary arraignment, you'll have your preliminary hearing where those 2 things need to be proven. If there's enough evidence to move forward, then you'll move forward to a different stage, to trial. But before the trial, you'll have a couple of the stops before the trial. You'll have the formal arraignment, where the charges again are read to you officially. you are able to file pretrial motions, or at that time, the clock starts with your pretrial motions, which we'll go on in a little bit more detail later on. And then you have your pretrial conference where you discuss the trial a little bit, discuss the trial date, your jury or non-jury, make sure everyone has the discovery, and is there a pretrial motions date needed? And then you go to the trial phase. And if you're unlike in the event that you have to move forward to sentencing, the sentencing will follow your trial. Judge?
Next slide, please. So when we talk about custodial detention versus arrest, you know, it tends to be somewhat of a continuum, but you have to know that people tend to believe that they are entitled to be read their Miranda warnings. An officer has to tell you that you have the right to remain silent. Anything you say or do can be used against you in a court of law. You have a right to counsel. Those are your, if you can't afford a counsel, one will be appointed on your behalf free of charge. Those are your Miranda warnings, but the Miranda warnings don't have to be read to you unless you are in custody and being interrogated. So in the event that you're not being interrogated, you're not entitled to your Miranda warning. So again, custody and interrogation equals Miranda warnings. Mr. Walker?
Yes, I agree. And also, people, they gloss over the Miranda warnings because they've heard it so many times. They're kind of numb to it. They just like, okay, yeah, I know. But no, they're telling you that for a reason. And they may read it quickly and you may think it's just a step in the process, but you really need to pay attention to it, because a lot of times people like to think, I can just talk my way out. Well, they're telling you have the right to remain silent. You should probably listen to them and just remain silent. Anything you say can and will use against you. Again, you should probably listen to them, because the odds are they're gonna have a body cam or a dash cam. And that stuff's going to be played against you at trial. And then imagine, you know, you on your worst day, you're picked up, you had too much to drink at a game, and later on you sober up and you're in your right mind, you have sober judgment. And next thing you know, you're claiming, hey, you know, I don't remember this. I wasn't that bad. Now they're showing you the videotape because you didn't know how to be quiet, and they use the evidence against you. And it's at trial. And it's pretty embarrassing to see yourself in the worst light on your worst day. And if you can't afford counsel, one may be appointed to you because you have the right to counsel. Again, if you're not able to afford counsel, public defender will be appointed to you, and public defenders are real lawyers, and there are some very, very good lawyers. So don't shy away from that. So these are your rights. Pay attention to them when they read them, because they're not just saying them for their health, they're saying them for your freedom.
If I may add, I'm sorry, if I may add, when you talk about the basis for detaining someone and investigating a potential crime or a situation, that intrusion on your freedom of movement has to be supported by reasonable suspicion. There has to be a basis to believe that there might be some criminal activity that is occurring. And that's all an officer needs to possibly pat you down or to stop you and ask you questions. Reasonable suspicion. To arrest a person or search a person, that has to be supported by probable cause. There has to be a basis of specific articulable facts which gives an officer a belief that a crime has occurred. So you cannot be searched or arrested without probable cause. So again, there has to be some belief by the officer that there are specific facts that have led him or her to conclude that a crime has occurred. And then an officer can search anything within your wingspan. They can search the person, search incident to a lawful arrest. They don't need anything more than probable cause to arrest. Gives you probable cause to search. If you did have a cell phone on your person, they could search your cell phone. If you consent to the search, if you don't consent, then they obviously would have to get a search warrant. And again, your search warrants, your arrest warrants, they all must be supported by probable cause. And a wingspan is if you were in a car, anything within reach could be searched if it was within your reach and you were the subject of a lawful arrest. That would be the basis of a wingspan search. Anything within reach can potentially be searched as a result of you being arrested. Next slide, please.
The right to counsel. As a defendant in a criminal case in Pennsylvania, the accused has the right to an attorney. Please use that right and understand that right. If the accused cannot afford an attorney, one will be appointed to them free of charge from the Allegheny County Office of the Public Defender. The defendant will be interviewed to make determination of his or her ability to pay indigency. The defendant has the right to be competent and effective counsel. He or she also has the right to hire counsel of their own choosing, and the defendant has the right to represent themselves with no attorney. Now, all of those, I agree with it. That's the law. Now, that last one, you do have that right. It's not recommended. It just isn't. mean, it's been stated that an attorney who represents himself has a fool for a client. Now, you have the absolute right to do so, but understand attorneys go to school for a reason. Attorneys have training for a reason. Attorney has experience for a reason. She or he can represent you the best way possible if you let them. And again, I also like to shout out my public defenders, because I understand the label that they have in society. You know, they don't do well. They plead people out. They're public pretenders. That's just not true. That's far from the truth. That's what people have been told about them, and that's just not true. There are some very, very good public defenders out there. I, as a private attorney, started my office. I started my practice with the Office of not the Public Defender, but the Office of Conflict Counsel, which is the parallel to the Public Defender's Office. We got their conflicts, so I worked very closely with them. The judge, as I'm sure he'll tell you, he ran that office. So they have some very talented attorneys there. So if you're in a situation where you cannot afford an attorney, please go to the Public Defender's Office and rest assured you're going to get some top-notch legal representation. Judge?
Thank you. I would agree. And I think, unfortunately, sometimes when things are free, people don't, they don't value them because there's no cost associated with the service. But the truth of the matter is, public defenders are in court every day, all day. They have exceptional training, exceptional attorneys as a whole, and they are more than capable of assisting you through the process, especially in the event that you don't have the resources to hire your own private counsel. But Mr. Walker did say, no souls are saved by a person deciding to represent him or herself. I mean, you're definitely at a disadvantage, and it is true. The client that chooses to represent himself or herself has a fool for a client. So it's never a course of action that we would encourage or recommend. Next slide, please. Questions?
Questions?
I do see a question that's in the chat that I don't think we got to. Someone asked, what is wingspan when you were talking about searches?
So a wingspan would be within the area of your reach. If you were to be operating a motor vehicle and ultimately you ran a stop sign, that interaction with the officer resulted in the officer, his level of suspicion materialized into probable cause, then that officer, under some circumstances, might be able to search the interior of your car based upon his probable cause to arrest you. He could search the wingspan of the car. He could search any area within reach in that car based on his probable cause to arrest. He would be unable to search your trunk because that is not within your wingspan. But the interior of the car, anywhere within the interior that you could possibly reach under some limited circumstances, probable cause to arrest would be the same probable cause which would support a search of the interior of that car. If you opted to search, if the officer opted to search the trunk of the car, he or she would need to get a search warrant, which would also have to be supported by probable cause.
There is one more question. Who cross-examines witnesses in the hearing?
At the preliminary hearing, the attorney does. The attorney will cross-examine the witnesses, cross-examine the officers or whoever's called on behalf of the Commonwealth in order to meet their burden of prima facie evidence, which is, again, just enough evidence to move forward. The attorney will make those questions, to pose those questions to the witness.
So if I may, if you think about a trial, there's two halves, like there are two halves to a football game. The first half is the Commonwealth, the moving party. They call their witnesses. They will do a direct examination of their witnesses. They will call their witnesses to testify. Opposing counsel will then have the opportunity to cross-examine those witnesses. And then once the Commonwealth rests its case, then defense counsel has the opportunity to call its witnesses and do a direct examination. And then again, the Commonwealth would have the opportunity to cross-examine those witnesses. So it's like two halves to a game, two halves to a trial, but the moving party usually goes first. The party that has the burden, the plaintiff, the Commonwealth, they will go first in a trial. And because they are going first and is their case in chief, they have to conduct a direct examination of their witnesses, while opposing counsel would do cross-examination, and then the roles reverse in the second half of the trial when the defense counsel is presenting its case in chief. So each party may be in a position where they cross-examine witnesses, but you can only do a direct examination of the witnesses that you elect to call. Opposing counsel can do a cross-examination of your witnesses to test their testimony for accuracy and the veracity of that testimony, for accuracy and truthfulness.
Or
Can
no-
I suggest we move on to another question? We're going to see some of
Yes.
this actually in the slides that we're coming up to, please.
Okay,
Great.
now we're moving to the Magisterial District Court, preliminary arraignment and preliminary hearing. Allegheny County Magisterial District Courts. The websites are there. There are 46 magisterial district courts with the magisterial district judges in Allegheny County, AKA the 5th Judicial District of Pennsylvania. All prosecutions initiated with the arrest by City of Pittsburgh Police will have preliminary hearings at the Pittsburgh Municipal Court building, which is pictured on the right there. Judge?
I would just say simply that the majority of your criminal conduct, because the city of Pittsburgh is so large, it's larger than, say, Monroeville, it's larger than Penn Hills. So the city will have the largest number of crimes given the size of the city as a whole. But any charge that occurs in the city of Pittsburgh will, that preliminary hearing will occur at the municipal court building and down next door to the jail on, what is that, First Avenue. But if a charge arose in Penn Hills or in Monroeville, then you'd have a preliminary hearing in Monroeville, because again, that area has jurisdiction over the case. So the case must begin in the territory where it began, where the case initiated, where the crime occurred. So again, if you commit a crime in Wilkinsburg, or you allegedly commit a crime in Wilkinsburg, you'd have your prelim in Wilkinsburg. If you allegedly committed a crime in East Pittsburgh, you'd have a preliminary hearing in East Pittsburgh. All cases will ultimately matriculate through the court system and end up in the Court of Common Pleas, but they must begin in the jurisdiction where the crime allegedly occurred. Next slide, please. So again,
Okay.
go ahead.
The jurisdiction of the magistrates in Allegheny County, civil actions less than 12,000, such as landlord-tenant disputes, small claims, summary offenses and traffic violations. They issue criminal citations, summons, and search and arrest warrants, summary trials for non-traffic offenses, fix and accept bail at preliminary arraignments, and hold preliminary hearings for misdemeanor and felony charges except murder and voluntary manslaughter, which those are in the separate room in the preliminary hearing in the magisterial district building, but in a separate courtroom. Judge?
Next slide, please. So when we talk about preliminary arraignments or bail hearings, that is simply within 24 hours of your arrest. If you're not brought into the system by way of a summons and you are actually arrested, you must be told within 24 hours of your arrest the nature of your charges, and you must have an opportunity to be told what your bail is or any conditions of bail. In some instances, you'll be released on your own recognizance, which means you'll be released without having to post bail. If the charges are not very serious, that typically will occur. In some instances, if the charges are very serious, like a homicide or a robbery, an armed robbery, you may be detained pre-trial without bail, without a condition of bail, given the concern about the safety of the community or the likelihood that you might not appear for trial. So when we talk about bail hearings, that's the only question is, one, what are your charges? And two, will you be released pre-trial while you await your case going through the system to ultimately be resolved in the Court of Common Pleas? So yeah, bail hearings have to be held at that initial stage, and you have to be told what your charges are. But the question for the accused is, will you await trial in jail, incarcerated, pending trial, or will you be on the street? And you could have conditions of pretrial release, which might require you to be on house arrest while you await trial. You might have to post money. A condition of bail might be a monetary condition. You might have to check in with the pretrial services. There are a number of conditions that can be required pending your release, but the question simply put for a preliminary arraignment is in or out. Are you in because the charges are so severe or serious, or we're confident that you might not show up, then you will be detained pre-trial. If the charges are not that serious and there's no concern about you being a flight risk, then you might be released pending trial without having to post any money or monetary conditions or have any other significant conditions.
I think, as the judge mentioned, that there are two considerations for the judge who is setting the bail. One, are you a flight risk? Will you show up? Two, are you a danger to society? Do I need to protect society in some way, shape, or form by doing a modification or a stipulation or condition for your bail, such as house arrest, do some classes, stay away from someone or someplace. Those are some types of conditions the judge can set on you. Now we're talking about the preliminary arraignments and who attends these hearings today. Magistrates are on duty 24 hours a day, 365 days a year to conduct arraignments. The building is right behind the jail. Representatives from the DA or PD, public defender, may appear in person at the preliminary arraignment. The defendant is also entitled to hire private counsel of their choice. Currently, defendants are not present in the courtroom in person. They remain next door in the ACJ and appear via video conference, and that's due to the pandemic that we are currently coming out of. And that's why they're doing the video conference. The magistrate must notify the defendant of the actual charges, the date and location of the preliminary hearing, the right to the attorney of choosing, or to assign an attorney at the preliminary arraignment, at the preliminary hearing. Finally, the magistrate is to determine whether or not to continue to incarcerate the defendant until the preliminary hearing, which we just spoke about, which is bail. Now, a couple of things to remember from this preliminary arraignment. The judge is going to give you, she is going to hand you a stack of paperwork. This is the thick paperwork we talked about earlier that could be mailed to your home. When the judge gives you, again, not you or someone you know, the judge will give that person paperwork. Make sure you instruct that person to hold on to that paperwork. A lot of times people just look at it and say, I don't need that, and they toss it. Well, you want to make sure you keep that, because if you're going to hire an attorney or speak to the public defender, you want to make sure you have that paperwork so you can hand it to them. So the attorney is not listening to what you remember. They can just simply read it on the paperwork that is in your hand, hopefully. So please make sure you or someone you know has that paperwork and they keep it. So when you pick someone up from jail on bond, pick someone up from the preliminary arraignment, make sure, hey, where's your paperwork? Make sure they have that. Judge?
Next slide, please. So again, bail release options, you can be ROR, released on your own recognizance, which means you don't have to post any monetary condition. You're just free to leave with the understanding that you have to stay out of trouble and appear at all subsequent court dates, appear for all subsequent court dates. And so again, as a non-monetary condition of bail. Sometimes it can be house arrest. Sometimes it could just be you simply keeping in contact with pretrial services by phone. They may require you to stop in once per week while your case is pending, but you do not have to put up any money. There are also times when you could be released on an unsecured bond. They could say, I'm going to release you on an unsecured bond of $5,000. You don't have to post the money, but the acquit, we basically give you credit for posting $5,000, even though you didn't. But in the event that you fail to show up, then a bond would be required to get you out of jail, a bond in that amount. And then there's also monetary conditions of bail, which means that if you, a district judge could always say, I'm going to set your bond at, $20,000 at 10%. That means you'd have to post 10% of that $20,000 in order to get out while you await trial. In the event that you are unable to post that 10%, which would be $2,000, then you obviously would have to stay in jail until your case is resolved. And again, and there are also situations where the charges are so severe or so serious that you would not be released because of a concern for the safety of the community or the likelihood that you might not appear for trial. And in that instance, you just would be denied bail. And that happens quite often when the charges are serious.
Now, there is another level to this, to bail. And I don't know if we'll speak about this, but I'll go ahead and address it now while I'm thinking about it. If you are currently on bail and you happen to get arrested for another charge, even if they set a bond on that second charge, the judge may detain you until the resolution of that second case, since you were already on bail on that first case. So in simple terms, if you have no priors, you're not on bail, and you get arrested for a crime, you get a bail, you post it, you're out. If you are already on bail and you get arrested for another crime, the judge may issue a detainer or a holder on you. So even if you post a bond, you're not able to get out, excuse me, because the judge is holding you until that resolution of the second case, because you got in trouble again, allegedly, while on bail for a crime, for a case in front of that judge. So just keep that in mind. Next slide.
So at a preliminary hearing, that is your first opportunity for you to confront your accusers. Now, that does not give you the right to present a defense. It is not a trial. You can't present an alibi defense. You can't testify and offer an explanation for the likelihood that you did not commit the crimes that you've been accused of committing. But this is nothing more than the Commonwealth's obligation to put forth evidence to suggest that more likely than not, a crime has been committed and you committed the crime. And if the Commonwealth can meet its burden as a prima facie case, which just means that basically they've put forth testimony that establishes every element of a crime. If it were a robbery, they've put forth credible evidence, although credibility is not a determination at a prelim because it's not a trial, but they've put forth evidence to suggest that someone had their property taken by force or threat of force, and the person accused is likely to be that person, then obviously those charges will be held for court and they would go to the next stage in the process. Again, you can't, because it's not a trial, you can call witnesses, it's not advised, but you don't want to testify because as the accused, anything you say can be used against you. So you would never see the accused testify because that would really be akin to presenting a defense. And since it's not a trial, you can't present a defense, but the Commonwealth does have a burden. And there are a number of things that can happen at the prelim, but ultimately it is the Commonwealth's burden at that first stage in the process to put forth evidence to establish that more likely than not, a crime has been committed and you committed it. And that's their burden at a prelim. Next slide.
Preliminary hearings, what are the benefits? There are numerous benefits to a preliminary hearing. One is the few opportunities a criminal defendant has to assess the witness and the physical evidence against you, to get a preview of what the case looks like, a chance for the officer and DA and the defense counsel to speak, and a resolution can be negotiated to avoid the time and expense of a lengthy trial. And there are circumstances where a defendant chooses not to have their preliminary hearing and instead waives it. Some of these circumstances may warrant waiving a preliminary hearing, or the DA agreeing to withdraw charges, or the DA agreeing to reduce bail. Now, in some, there's a lot of willing and dealing going on at a preliminary hearing, especially when you're down in Pittsburgh, and I imagine in Philadelphia also, in the hallways, because everyone's scheduled at the same time. So everyone's going to be waiting for the hearing. You're going to see the attorneys and the prosecutors and the officers running in and out, talking, discussing, and a lot of times they're discussing, hey, why don't you withdraw this charge in exchange for this, or why don't you reduce this charge, or you really can't prove this charge, or why don't we agree to some classes or some community service. And a lot of times your case could be resolved through effective counsel with representation outside in the hallway. And you come into the courtroom, now you have an agreement, the case either gets dismissed, the case gets reduced down to a lower offense, or the case can get waived downtown, but with lesser charges. So there are numerous benefits, and it's really strongly advised that you have an attorney so you can exercise all of your rights and receive all those benefits at a preliminary hearing. Judge?
Next slide. The other benefit to the preliminary hearing is also that if your accuser is testifying, their story, their version of events is recorded by way of a transcript. So there's locked into a version of events and they're locked into a story, which that if they, at some point down the road, when that case reaches the trial stage, if they're unable to clearly recall facts that they testified to at the prelim, then obviously that inconsistency would bear on their credibility. So it's always good to have a transcript produced at a prelim so that you can then use that to impeach witnesses during the trial phase. But there are just a number of things that can happen at a prelim. So the Commonwealth can meet its burden. They can put forth evidence to establish that a crime has been committed, and those charges will be held for court. In some instances, they may amend the criminal complaint to add additional charges or withdraw charges. Sometimes charges get dismissed because witnesses don't show up or they just don't have the evidence to proceed to trial, and those charges may be dismissed at a prelim. They may also list the charges because of a lack of evidence. The judge rules that the Commonwealth did not meet its burden and there's no evidence to support the charge, and the charges are dismissed. And in other instances, the testimony might establish, while it doesn't establish an indictable offense, a misdemeanor or a felony, it may establish a summary offense. And in Allegheny County, district judges only have the authority to rule on summary offenses. So they could find you guilty of a summary offense. They can never find you guilty of a misdemeanor or a felony. They don't have the jurisdiction or the authority over those charges. They can only hold those charges for court or dismiss those charges for lack of evidence or lack of prosecution. But when it comes to summaries, they could always dismiss the felony and the misdemeanor and find you guilty of summary offenses if they exist.
So what does this mean practically? How does this work? Let's say, for example, you're charged, you or someone you know is charged with possession of controlled substance and possession with intent to distribute that controlled substance. But at a preliminary hearing, because the possession with intent to distribute is a felony, the simple possession is a misdemeanor, the officer and the district attorney and your attorney may agree to withdraw the felony charge and waive the misdemeanor downtown. So that saved you a felony charge, definitely penalties and fines, and a little bit of aggravation of going downtown to big court with a felony offense on your docket as you move forward. Now your case moves forward with just a misdemeanor. So it's kind of a little bit easier to resolve when it's just that misdemeanor as opposed to the felony and the misdemeanor. So that's how it works practically in real life. Next slide. Questions and answers.
We do have one question. So the question from Mark is, regarding the Fourth Amendment, what are some of the criteria for deciding how it applies to the searching of online communications or other evidence as opposed to physical evidence?
So I would say that when we talk about the Fourth Amendment, it gives everyone a right to privacy. So in order for the government, a police officer, to intrude or invade or impose upon your right to privacy, that ability to do so must be supported by probable cause. It must be supported by probable cause in the terms of an arrest and a search incident to an arrest, or it must be done so by the person's consent. They consent to give you the ability to impose upon or invade their right to privacy or impose upon their right to privacy. Or last but not least, a judge somewhere has to make a determination based upon the evidence that is sworn to them that probable cause exists to give that officer the ability to search. So when it comes to a phone, when it comes to a house, when it comes to a purse, you know, you name it, if you have an expectation of privacy in that item or in that space, the only way a search can be conducted is if it's supported by probable cause following an arrest, or if there was a search warrant done by a judge or a district judge, or which was authorized by a judge or a district judge by way of a search warrant, or if you consent. But you have higher and lower expectations of privacy and different things. You have a higher expectation of privacy in your home than you do in your car. But any intrusion must be supported by probable cause.
Thank you.
Agreed.
One more question. There's a number of them, but I've got to pick and choose because I want to get on to the next chapter. So the last question is the security money for bail, for example, 10% refundable?
It depends on where you go. If it's with the court, I believe it is, and Judge, correct me if I'm wrong. I believe if you post it with the court, it is. But if you post it with a bail or bond agency, I don't believe it is.
So a bail agency will require 6% of the amount that you must post. If your bail is 10,000 straight, they will require 6% of 10,000, which would be, what is that, 600? Yeah, 600. So they would require, I went to law school because I didn't. But they would require 6% of 10,000 would be their fee. It would be non-refundable. If you opted to post the $10,000 on your own, you would get that money back at the end of the process, provided you showed up at every court appearance. But again, the bail agency will typically require 6% of whatever your obligation to post your bail, but that is a non-refundable fee.
Step 3, Court of Common Pleas, discovery, pretrial motions, trial, guilty plea, and appeal. Court of Common Pleas Criminal Division. Here's the criminal cases within the courthouse at Grant Street and Forbes. And the picture on the left is the old jail, and it shows the bridge of size connecting the two, criminal court to family division, which now operates in the former jail building. Next slide.
So when we talk about the Allegheny County Court, once your case has left the preliminary hearing and a district judge has determined that sufficient evidence exists to support the charges, your case will then process or make its way, progress through the Court of Common Pleas. So your next step in that process will be your formal arraignment. At your formal arraignment, you're provided with a formal charging a formal charging document called a criminal information. That will contain your charges. That will be given to you at your formal arraignment, along with a subpoena directing you to come back to a specific courtroom where a judge has been assigned to your case on a subsequent date, which is your pretrial conference date. And that is the time when you will be able to, with the participation of the prosecutor, the court staff, and your defense attorney, they will select a future trial date. They will notify the court as to whether or not it is your preference to plead guilty, to have a non-jury trial where the judge will decide your guilt or innocence, or whether or not you will have a jury trial. And that case will be scheduled. But in between your pretrial conference and your trial date, you must file any pretrial motions that you have. You'll be given a copy of your discovery, any police reports, body cam, any information contained in your case that the Commonwealth has obtained in the process of prosecuting you. They have to give your attorney a copy of that at your pretrial conference so that you can adequately defend yourself against the charges. The case is calendared, and pretrial motions will be scheduled. If there are no pretrial motions, again, your case will proceed to a trial, to a non-jury trial, jury trial, guilty plea, or pretrial motions. They'll all be resolved at a subsequent date. A motion in limine is just nothing more than a motion to exclude evidence. So, maybe you made a statement, a person made a statement during their arrest, and you file a motion in limine or a motion to suppress because you're saying, hey, this evidence should not be considered by the fact finder, a judge in a non-jury trial, a jury in a jury trial. So those are just types of motions that you file to exclude evidence from consideration. Next slide, please.
Why are so many guilty pleas entered in criminal cases? According to the Unified System of Pennsylvania, 66.9% of Allegheny County defendants pled guilty in 2019. In 2020, that number was 63%. There is a certainty of a plea versus the uncertainty of a trial verdict. Usually there's strong evidence against the defendant and its ability to use the weaknesses of the evidence to negotiate a favorable plea bargain. Essentially, this slide talks about plea negotiations and plea deals. Why would someone enter a plea? Well, the plea must be knowing, intelligent, and voluntarily made, and only you can decide to plead guilty. Your attorney can't force you to plead guilty. Your attorney can advise you. Your attorney can give you the pros and cons, the strengths and the weaknesses of the case, but only you as a defendant, potential defendant, can make the decision whether or not to plead guilty. But a lot of times people plead guilty because the evidence is against them and they want to accept responsibility for their actions and move forward. And there's some peace because there is a certainty in what you're going to get versus if you go to trial, there's a 50-50 chance of what could happen on a good day. And it can go either way and you just don't know. And the anxiety of waiting from the initial arrest to the arraignment, the preliminary hearing, formal arraignment, pretrial, all the way up to trial, waiting that long, that can be up to 18 months sometimes, maybe even longer. So a lot of times people think, well, I'm going to accept responsibility for my actions. I got a reduction in the charges. I got a good deal. I know when I'm getting 2 years probation, so I'm going to do it. So that is why people enter a guilty plea. And there must be a factual basis for that plea, which we'll get forward. We'll deal with a little bit later on. Judge?
Next slide, please. So you have your stages of a criminal trial, a criminal jury trial. You, along with your attorney and the attorney for the Commonwealth, will go down to the jury room and you would select jurors from a pool. Most of those, jurors will come from one of two public lists, driver's license list and the voter's registration list. So that's where we typically select our jurors from to come in to be available in the event that parties want to select a jury. And both parties to each proceeding have the right to a jury trial. The accused has a right to a jury trial, and so does the Commonwealth on most cases. There are some charges where you're not entitled to a jury trial by law. But after the jury has been selected, there are 14 jurors on every criminal case. There will be 14 jurors, 12 jurors, 2 alternates. The attorneys will then do their opening statements where they lay out the facts based upon their belief of the case and their belief as to what took place. And they'll encourage the jury to, in terms of the Commonwealth, they will encourage the jury to find the defendant guilty for the following reasons. The defense counsel will argue that you should acquit the defendant and not find him or her guilty based upon their view of the case and their view of the facts. After the opening statements, the Commonwealth will call its witnesses and they will do what's referred to as a direct examination. Defense counsel will do a cross-examination. At the end of that process of the Commonwealth calling all of its witnesses, it will rest its case and they will say, we're done with our case. We've completed our case in chief. The defense counsel will almost always make a motion for judgment of acquittal, whereby the defense counsel is saying, based upon the evidence presented that you heard from the Commonwealth, there's no basis to believe that a crime has been committed. Even if you believe everything they said that testimony does not establish the commission of a crime, therefore you should dismiss the charges. And that's the standard that the judges have to use when we entertain a motion for judgment of acquittal. In the light most favorable to the Commonwealth, does the evidence suggest that a crime has been committed? The answer to that is yes. Then defense counsel has the option to do one of two things. They can rest, and then everyone would do their closing arguments, and then I would instruct the jury as to the law and give them an opportunity to deliberate and reach a verdict. And the alternative, defense counsel could say, okay, we will now present our case in chief. They'll call their witnesses and they'll do a direct examination. The Commonwealth's attorney would do a cross-examination. They would all do, again, closing arguments. I would instruct the jury on the law. Jury would be encouraged to deliberate. They'd reach a verdict, and whatever that verdict is, all the parties would have to live with it, and that would conclude the case. And in Allegheny County, in Pennsylvania, your jury verdict must be unanimous. It has to be unanimous to find the person guilty. All 12 people have to say guilty, or all 12 people have to say not guilty in order for the verdict to be official. And if they do not reach a unanimous verdict, then it's what we refer to as a hung jury or a mistrial, which means we'd have to try the case again because there was no complete and full and final resolution of the charges. Every decision has to be unanimous. Next slide.
Just kind of went over this. There's possible jury trial outcomes: guilty, not guilty, mistrial, or hung jury. So there's no need to belabor the point on this. Next slide. I'll take the next slide since this was kind of quick. Pre-sentence report and sentencing hearing. Adult probation may contact the victim, who will receive a form asking them to submit a written victim impact statement. The DA may ask witnesses to appear to give an witness impact statement or a victim impact statement. The defendant or defense counsel may ask character witnesses to give statements. And the defendant may also testify what the judge calls, or what the court calls, the actual system calls, the right of allocution, which means you can tell me what you want me to know as the defendant, tell the court what you want them to know prior to rendering a sentence. Before sentences, court and attorneys will read what they call a pre-sentence report and mental health report completed on the defendant to inform the judge of their sentencing arguments. Sometimes attorneys like to file sentencing memorandums. That's normally not the practice in state court, at least in Allegheny County. That's more in federal court. But typically you'll review the pre-sentence report with your client, make any edits, corrections, or changes to it. And then you want to make your argument to the judge as to what is a fair and just sentence. So what is a sentence that a lot of times it is a fair and just sentence, or a sentence that is sufficient but not greater than necessary, or that's in the best interest of justice at that time. What does justice require at that sentencing? Does justice require this person getting probation, house arrest, incarceration, a year less a day versus a year addition to a year, which is a prison sentence? What does justice require in this case? And every case is different. Just because you may know someone who got probation on a certain case doesn't mean the next person is going to get probation on the case, or the next person is going to get house arrest on that case. Every single case is different. So you can't base the outcome of another case on your case. Every single case is different and unique, and you must have an attorney put those unique qualities before the judge so the judge can make the best decision for that case. Next slide.
So when we talk about post-trial motions and post-sentencing motions, once a person has been found guilty or has pled guilty, they have 10 days to file post-sentencing motions. And once they've been sentenced, they can file motions challenging, it depends on if they pled guilty or if they had a trial, but they can ask the judge to dismiss the charges, to reconsider their sentence, to take another look at the evidence. They can do those things. They can ask to withdraw their guilty plea within 10 days. Is that window of opportunity to challenge anything that happened in that proceeding prior to you being sentenced. After the 10 days has run, then you have 30 days to file an appeal to the Superior Court. And as a matter of right, you can appeal anything that happens in the Court of Common Pleas to the Superior Court, but it must be done within 30 days. And the judge has 30 days to respond. If the judge, actually 120 days. If the judge does not respond within 120 days to your motions that you filed within that 30-day window, then they're deemed to be denied, and your case would then be resolved by the Superior Court on appeal. But you can't appeal a decision because you don't like the decision. On appeal, it's your responsibility as the appellant, the person moving the appeal forward. You have to establish that there was a legal error that was committed during your trial, and you're asking a higher court to take a look at that and instruct the judge to either do it over, to fix it, or to withdraw the charges and discharge the case completely because of that legal error. So some people think just because they're found guilty or because they lose in court, they can appeal the case. You can appeal as a matter of right to the Superior Court, but it has to be on the basis of a legal error that you're claiming has occurred. Next slide.
Appeals of conviction. The Commonwealth is not able to appeal a not guilty verdict. Defendant, just like the judge said, had to file a notice of appeal within 30 days. They have 10 days to file the post-sentence motions. The judge has up to 120 days with an optional 30-day extension to rule on those motions. If they don't do it within 120 days or 150 days, depending on that extension, is deemed denied by operation of law. And then you have the right to file your notice of appeal to the Superior Court. The defendant may appeal, therefore, after, if all your appeals have been denied or the lower court has been affirmed by the Superior Court, you may appeal to the PA Supreme Court, but the PA Supreme Court has discretionary review. You don't have the appeal of right to their court. In non-death penalty cases, whether or not to hear the defendant's appeal, which is a request or petition for what they call a la carte, to hear this case before the court. And it has to be a case that will impact all the counties across the Commonwealth, not just here. For example, if it's a case involving a constitutional right, or if it's a case involving a certain issue that all defendants would benefit from, or if it's a case that certain counties are deciding one way and certain counties are deciding a different way, the Supreme Court may decide to take that case just to make sure everyone understands what the law should be at that time moving forward. So you do not have an appeal of right to Supreme Court. It's a discretionary appeal with the PA Supreme Court. Next slide.
I would just add too that when you talk about death penalty cases don't go from the Court of Common Pleas to the Superior Court. They go directly to the Pennsylvania Supreme Court, given the nature of the penalty, death. They automatically go directly to the Supreme Court. So those are the one case where there is no Superior Court involvement. It would just go directly to the Supreme Court. But questions?
Wonderful. We have one question that I'm gonna take, and then we're down to the wire, and I want to respect everybody's time. So we have probably about 4 or 5 more slides. So the one question is, do all prison times, including before the preliminary hearing, go on the record?
Okay, so I think that question is, do you get credit for any time that you serve? If you are not incarcerated as a result of a sentence, then you will not get credit. Well, let me back up. Pre-trial detention, it will always go towards your ultimate resolution of your case. If you spend 6 months in jail awaiting trial, you plead guilty, you will get credit for time served. But if you're on house arrest, awaiting trial, you do not get credit for the time that you served on house arrest. But pre-trial detention, you will always get credit for that time that you have served. If you're unable to post bail, that time goes to your sentence when your case is ultimately resolved.
Great. So maybe since we're really down to the wire, we're going to skip the last couple of slides, and I think we're going to ask 1 or 2 more questions. I think the questions for our participants it might be more important. So another question. Let's see. The last question is, in Allegheny County, what percentage of trials end in verdict of a guilty?
Actual trials, including bench trials and non-jury trials, I do not have the answer to that, and I'd be surprised if the judge does. I'd be impressed if the judge does, or anyone does.
There's really no way to really quantify that, but I can tell you this. Under the leadership of the past director, who was an outstanding director, the Public Defender's Office had a 66% acquittal rate. So that means 2 out of 3 cases resulted in not guilty, because of the work that was being done on the front end with investigators and with gathering the evidence and working the cases up. The Public Defender's Office had really a lot of success during trial. But there's really no way to say how many cases end in a conviction. But most will say, if you took 100 cases, 96% of those cases will end in some sort of conviction, one way or another, whether it's guilty plea. In most instances, it would be a guilty plea, but there's no way to answer that question. I don't have an answer.
Great. Okay, thank you. One more question. Does a jury also deliberate the sentence itself?
No.
Not
Unless it's a death penalty.
right. Here, in some states, the jury will answer the question of guilty or not guilty, and then they will affix the penalty for the conduct. Here, juries determine guilt or innocence, if you will. Judges impose sentencing. So the jury would never be involved in determining an appropriate sentence for a person. That does not happen.
Right. And then our last question, and thank you for everybody's time, is does all prison time go on public record?
So yes, the answer to that question is yes. If the question is there a record of the sentences which are given out in each individual case? Yes, our docketing system keeps track of each case, the charges that were initiated, the charges that were ultimately held over for the Court of Common Pleas, and the charges that were ultimately resulted in a guilty plea, a jury verdict of guilty, a non-jury verdict. All those charges, every step of the way, that is documented. And then any sentence which is imposed as a result of those charges is also of public record by way of our docketing system in the Allegheny County Court of Common Pleas. What is it?
UJS.
What is it called?
UJS.
UJS, Unified Judicial System. And if you go to the Allegheny County UJS portal, you can look up, get a person's name, do a participant search, and you can find out any sentence, any charges, any landlord tenant, anything that was initiated in a preliminary hearing or in a magisterial district court and worked its way through our court system. There will be evidence of it there, and you can find all the answers to those questions.
Wonderful. Tom, I'm going to turn it over back to you to close it out.
Thank you. We'd like to see some of the programs that we have coming up in April. PMC offers a variety of programs, not just criminal law. April 6th, Carnegie Library and Allegheny County Law Library will be discussing how to administer an estate. That's a lunch and learn program. We are on April 12th looking at a threat to the Pennsylvania Constitution, where we're looking at allegations made as to possible legislation that affects the Pennsylvania Constitution. The moderator is Judge Frederica Messiah Jackson. On April 20, we have a court basics program at the Bethel Park Library. And then on April 21st, we have another how to administer an estate, which is being hosted by Mount Lebanon Library, Jefferson Hills Library, and Pleasant Hills Library. And we close on April 28th, a landlord tenant at Northern Library. All of these workshops are free and open to the public. Thank you to Judge Howsie and Attorney Walker for taking the time to present and give your excellent background and information on all these topics. We appreciate it. And thank you to the Monroeville Public Library for hosting this civic education workshop. PMC has PMC Watches, which is the example being the Bail Watch. And we also have PMC Shares programs like you saw this evening. Thank you very much to everybody. Hope you have a good evening.
Thank you.
You can find this recording on pmconline.org.